I'm delighted to be here chairing this session. It's the start of a busy 3 weeks with our FinReg Centre. It's the first of 3 events. So we have this webinar today, and next week we have an event on corporate crime, and then we have another event on the future of financial regulation. Both of those next events are in person at Isles. But before that, we have this webinar today with Tristram Hicks, who is an expert on anti-money laundering. He has been involved in this as on the law enforcement side and on the consultancy side. And he has recently co-authored a book on the war on dirty money. And Tristram, thank you so much for joining us today. We're delighted to have you. I'm not giving a biography about your background, because I know you're going to open up and tell us all about your background and why you were the ideal person to write this book. First of all, congratulations on writing it, and I'll pass it over to you, Tristram.
Well, thank you very much, Colin. It's a pleasure to be here, to have a chance to talk about the war on dirty money, which Dr. Nicholas Gilmore, who's based in New Zealand, and myself wrote, published by Bristol University Press. And my experience is on the law enforcement side. So I was a detective superintendent at New Scotland Yard, and I bring 30 years of experience to this topic. 15 years of crime fighting in South London for the Metropolitan Police, and then working for a specialist unit, the Economic and Specialist Crime Unit at Scotland Yard, for 10 years. And at the same time as being in operational command of all the Metropolitan Police financial investigators, I was also on the National Committee implementing the then new Proceeds of Crime Act, which changed everything. The Proceeds of Crime Act was a real success story for the UK in terms of the amount of assets recovered from criminals after 2002, when that act was passed. In 2009, I moved into international work and had the privilege to travel the world, Europe, Africa, Caribbean, Asia, helping countries and agencies to recover more assets from criminals. And I kept coming across the same generic issues all over the world. And I thought, well, there's something to be said about this. So that's the origin of the book. The book needed to be writing because the same issues were occurring across the world. And I felt there was something useful to say. So this is a book about solutions. So it's not about crime, it's not about criminals. So many books are already doing that. This is about the war against dirty money, how the systems work, how the agencies work, how governments work, how the regulation of financial matters works, and how it could work better to solve some of these generic problems. So that's the origin of the book. It needed writing, and Nick and I brought something to it in terms of decades of expertise. And we say in the book, we don't think it'll be out of date. We hope the book will go out of date, but we don't think it will, because we think the problems are so deep-seated, so cultural, misunderstandings, things that are quite difficult to fix. But we offer some solutions, and the book is divided into 20 chapters. It's arranged in the same order as the Financial Action Task Force evaluation process, which we'll come on to. So each chapter has a toolbox of solutions at the end for each part of the book.
Thanks, Tristram. So we're going to run this session as a Q&A. So I will get the ball rolling, but if anyone in the audience has any questions, please do type them in the chat, and we will pose questions to Tristram throughout the next hour or so. Tristram, just to start off then, one of the things that you say at the outset of the book, and I really enjoyed the book, it is very thought-provoking. It does get a conversation started on AML issues. But you say early on, everything is tainted by money laundering. Can you say a bit more on that?
Yeah, we all deal with money. All of us have some money, however large or small, and a lot of the money in the world is dirty money, and in particular, a lot of money is taken from the public purse, either because it never goes into the public purse because it's been the tax has been evaded, or it's been stolen from the public purse inappropriately, and that means that in poor countries and in rich countries, the public services, our health services, our education, our security in terms of police, all of those are less good than they could be because of this absence of money in the public purse. And therefore, the money laundering, which is no more or less than the handling of stolen money. People think it's complicated, but it's just that, the handling of stolen money. It's taken from the public purse, and we're all poorer as a result, and that's why it taints everything.
So over the last 3 or 4 decades or so, we have seen this huge growth in AML. You mentioned FATF, the Financial Action Task Force. We see a lot of action here in the UK, most notably with POCA in 2002, but numerous revisions subsequently. There's not a year goes by without numerous cases on proceeds of crime or money laundering. Alongside that case law, we have seen the emergence of the compliance industry, or what Antoinette Verhaeghe has described as the compliance complex. That all costs money, it costs time. But then we're back to a simple question with probably not an easy answer. Does it work, or is anti-money laundering effective?
Well, to a large extent, we can't really tell. We invest around about $210 billion and rising, according to LexisNexis, who are leaders in the field. And how do we judge success? It's very unclear. It's very difficult to judge. Prevention is to be said in fairness, but actually judging success is very difficult. The way we choose to judge it is through the confiscation of criminal assets, and some estimates put that as low as 0.1% of the money available to be confiscated is confiscated, and at the higher end the estimate is a mere 1% of the money available to be confiscated. So by that measure, we are not doing well, and we haven't really come up with another measure. So we're reliant on a rather simple measure of monetary success, which doesn't really tell us much about crime. It doesn't tell us about the harm caused by money laundering. And we're spending an awful lot of money, and we could do more academic research, I feel, on how to measure money laundering better, and to have some better metrics to choose on how we evaluate country to country and around the world. At the moment, it's hard to tell.
I think that leads nicely into FATF and their methodology for effectiveness. And you look at this in the book, and their 3-pronged approach: policy, prevention, prosecution. What are your thoughts on FATF's approach to measuring effectiveness, and particularly the shift from just looking, is there compliance, to effectiveness?
Yes, okay, so let's talk a bit about the Financial Action Task Force. So this was started in 1990 by the OECD, for want of a better expression. The rich countries invented it because they were concerned about drug consumption, particularly in America and to some extent in Europe. They were also concerned at the time about tax evasion, though somehow that got lost in the process of working out what crime was. And we should start with that. The FATF started with, what is this money laundering coming from? And they came up with a list of what they call predicate offences, offences which are capable of generating money, which is everything you can think of, from extortion to kidnapping to drug dealing to simple theft. all the offences capable of generating money, apart from tax evasion, which somehow got left off the list in 1990 and wasn't added until 2012, which is quite a long gap before that important predicate crime was actually addressed by the global standard setter. So the FATF started as a pretty small secretariat, still quite small, based in Paris, and they have regional bodies, which are FATF-style regional bodies based around the world, with groups of countries which they evaluate. And each country gets evaluated 8 to 10 years, which is probably too long. And each evaluation provides a snapshot of what the country looks like in terms of anti-money laundering systems and money laundering risk. And there are some weaknesses to the evaluation process. But overall, I'm a fan of the FATF, because they started with, remember, money laundering wasn't a crime. So they managed to get money laundering as a crime in every country. Every country has a financial intelligence unit providing that interface between the financial sector, the banks, and law enforcement through suspicious activity reports. And they each have a committee or a mechanism to check that system of money laundering, criminalisation and FIUs, to check it exists. So we have these three things in every country, which the FATF created. The weakness, I feel, is that the assumption at the beginning was if the financial sector complied with the regulations, then that would automatically prevent money entering the financial system. And I'm not sure the logic of that has ever really been properly tested. And it does seem that we've ended up with a tick box system which looks at the regulations, looks at compliance to those regulations, and ticks the box. That satisfies the bank that they're doing the right work in compliance, and that seems to satisfy the regulators that they are complying, and all of that should lead to there being no dirty money in the system, and yet the system seems to be awash with it. So there's something going wrong, and it's, in our view, the system isn't joined up. And if it could just be brought into focus, if we take the infrastructure that the FATF has created, that hundreds of thousands of people are actually working on in the financial sector and what's called the reporting sector, which reports suspicious activity reports into FIUs, into law enforcement. There's a lot of people working on this, but they're not operationally effective, it seems. And the reason I say that is the FATF used to produce evaluation reports, 300 or 400 pages per country. And I'd read these things and think, well, there's a lot of information here, but does it work? Does anti-money laundering work in this country? And I found after 300 or 400 pages, I couldn't tell, and nor could anybody else. So in 2012, they changed the methodology to include operational effectiveness. And since 2012, that's been included in the evaluation process. And now we have, in addition to the 40 recommendations and the 9 special recommendations about terrorism, we have 13 immediate outcomes which we expect to see if we are being operationally effective. And that has changed the game. Personally, I think we should move completely away from those recommendations towards operational effectiveness, just because there's fewer of them and it's much easier to read and understand. So
one point that you made in relation to that, though, is you mentioned it has changed the game. Some people have said it leads to countries gaming the system, and that they are trying to tick the box to convince FATF that, look at us, our country is great at AML. And probably one example of that is the 2018 evaluation of the UK, which got top marks and the best in the world according to the government at the time. But I know you have criticisms of the UK approach as well. So how do you marry these two different points?
Yes, I do think it's a fair criticism to say that countries will game the system, but we haven't got anything else. The FATF is the standard setter. There's no one else in the game who's doing this kind of evaluation. So we have to take what we have and make it as good as we can. And I think it's also fair to say that countries are criticised. There's a criticism that the FATF evaluations favours rich countries and criticises poor countries. And if you look at the list of countries which are put on what's called the grey lists and the blacklist, those are poor countries. And they're not the only lists. There are other lists produced by the EU and by other international bodies. And those tend to pick on poor countries as well. So the book isn't about Britain, but Britain is a good example. And Britain did get full marks, the highest ever ratings when it was evaluated, as you say, in 2018. And to some extent, it deserved it. The Proceeds of Crime Act was a game changer, a story of success in terms of suddenly we were able to confiscate assets in the UK. And before the Proceeds of Crime Act came in, we collectively confiscated 100 million, well, 0.1 billion was confiscated in the 10 years before the Proceeds of Crime Act. In the 10 years after, it was 1.2 billion. So a huge, huge increase. And a lot of things that we did right in those 10 years were part of the evaluation, because the systems worked, the strategic oversight, the laws were implemented, and there was evidence that did work. So to some extent, the evaluation was correct. What the evaluation didn't look at, however, is the illicit financial flows between Britain and the rest of the world, because, as I say, the evaluation process looks at a snapshot of the country. It doesn't really tell you about the relationship between that country and other countries. And we escaped criticism because that part wasn't evaluated. We also escaped criticism because the report was very well written. The National Risk Assessment of the UK, very well written, and a work of art, and evaluated as such. Yeah.
No, I think just thinking there, you said as well about the book. It draws, of course, on the UK in many of your examples, but this is a global regime, and you are clear about that in the book. This is a book about the global regime, not about the UK. And that leads us nicely into a question here in the chat. Because, of course, you've been on your travels for many a year looking at AML confiscation. And we have a question here asking, what money laundering or what weak AML trends did you find around the world that most surprised you by their universal nature?
It's a great question. And one thing I would say about traveling the world is people are just people. So the cops in the UK and Australia and India and Zambia are much like cops everywhere else. And prosecutors are much the same. Judges are much the same. They have different legal frameworks, and they have different social norms deriving from those legal frameworks or integrated with those legal frameworks. So a lot of things that I found was the similarities between people and their approaches. So one of the greatest weaknesses is in the suspicious activity report regime itself, which is central to the AML regime. Now, if you think of this from being a money launderer, what is a money launderer? And a money launderer is someone who separates the information about the crime and the criminals, which they know about, from the information about the money. And that's all they do. I mean, the rest of it really is banking. So they're just separating those two bits of information, stuff about crime, stuff about the money. And if they can keep that information separate, then they're successful money launderers. Now, against that, we have a reporting regime which delivers the information about the suspicious money to the FIU, and that never gets as far, often enough, to the information about crime and criminals. So in some ways, the FIUs are actually acting like actual money launderers, because they're separating the information about the money from the information about the crime. And that's the most surprising thing. You know, if you think of it that way, that's a real problem. So we need to think about why it is that all these 34 million SARS, last was the estimate, I think, from 2019, go into the system and hardly any come out to law enforcement to be investigated. And really we need to look hard about why that is, why FIUs are withholding SARS from the end user to investigate. Because financial intelligence units don't actually investigate or freeze or confiscate criminal assets on a permanent basis. They can do it temporarily, but the end game rests with prosecutors and courts and law enforcement. That's where the information needs to be.
Just on that thing about where getting the information to the end user, so you do have the private sector feeding in, as you said, to the FIU, gathering the financial intelligence, and then the output going to law enforcement. But the first part of that, then the input, you do need the information from somewhere. And we have a question which is particularly contemporary at the moment. It's receiving a lot of attention in the news about the role of the legal sector. And we're asked here, could you say something about the role of lawyers in facilitating and challenging money laundering?
Okay, I don't talk about this in the book particularly, but I'm happy to talk about my experience. I was the single point of contact for suspicious activity reports for the London area. And my experience of SARS from lawyers is that they were far too few, but really good quality. So there is something about lawyers having access to really good information and not reporting it enough. And I think more should be done to encourage lawyers to make suspicious activity reports. I'm a fan of that. But part of that process is getting feedback from law enforcement back to the reporting sector in general. And we don't do it well enough in the UK or indeed anywhere else. And part of that is an inherent difficulty in the system, that we cannot give feedback about individual SARS related to an individual case for legal disclosure reasons, because that may not have been may have been protected within the system from being revealed. So we can only give feedback in a generic way, and I don't think people understand the rules of disclosure enough to give good enough feedback. I think there's more skill to be applied in giving good feedback to whoever makes an SAR, whether it's a lawyer or the banking system.
Tristram, I'll come back to this point about feedback straight away after this, but can I just ask a follow-up question without putting you on the spot, because I know it's not in the book, about the legal sector again. We see proposals for reform in Australia because lawyers there are not required to report because of legal professional privilege. There are similar issues in Canada, for example, where the Supreme Court said privilege trumps AML requirements. It's different here in the UK. Lawyers are required to file SARs in appropriate situations. What are your thoughts on this conflict between legal privilege, the duty towards the client, and the obligation to report suspicious activity?
Well, to be blunt about it, if the British can provide a system where lawyers make SARs, then the Australians and the Canadians should be able to as well. And it's a weakness in their system that this obvious source of good quality information is protected. And what it does is protect criminals. It's as simple as that.
And last point then on this issue of SARS there is, so you mentioned very good quality of SARS from the legal sector, but we all know the vast or the overwhelming majority of SARS come from the banking sector, and there have been suggestions that a lot of this is defensive reporting. Some suggest that the quality is lower, certainly than the legal sector. Do you have any thoughts on that?
Yeah, I do. I mean, there's a complaint made that far too many SARS are cluttering up the system. That's the allegation that's made, and that's why we invented computers, to stop all that cluttering. And I think there's a basic misunderstanding about what a SAR is and what it contributes. So a SAR from the banking sector is providing information about money that's believed to be suspicious, and it goes through a pretty rigorous process from the original cashier through the line manager through to the anti-money laundering reporting officer, and I think they do a good job. I'm a fan of that process. What then happens is that the information doesn't get any further, and it provides this, as I put it, the talk about the needle in the haystack, that there are far too many SARS and we're trying to find a needle in a haystack. Actually, the SARS from the banking sector are half a needle. They're providing information about the money which is suspicious, and it should be added to the half needle that the crime law enforcement agencies have, which is the other half of the needle, and put those two data sets together in a simple analytical process, and the needles joining the money and the criminal together will fall out of your haystack. That's what we should be doing, if that works as an analogy. And we're not doing enough to join the two halves together, because we analyse the SARS within the FIU, and we haven't got the information about the crime and criminals. So we've only got half the information.
Does this go back to your joined up approach, though? Because earlier you mentioned about the need for a joined up approach, and in the book you write about information sharing. You write about it in the context of law enforcement agency to law enforcement agency, but also law enforcement agency to private sector sharing of information. Information might be there, but if you don't have this joined up approach, if people aren't talking to each other, particularly agency to agency, what then?
Yeah, okay, so we've got several things going on there. I think I'm a believer in private-public partnership in terms of sharing information. I think that the GIMLET system in Britain is good. Personally, I don't think it's particularly new, because I was sharing information under the previous system, which was the FIN. It was called the Financial Fraud Interagency Network, which was set up in 1990 after the BCCI scandal, and that was meeting at what was then the FSA. And they've been sharing information between public and private for all of that period. So that works quite well. I think there is a danger of leading that into enforcement, because I think when the private sector gets involved with criminal law enforcement, then there is a real risk of a conflict of interest between an investigation in the past and providing information about enforcement in the present or the future. So I do think there's a limit to the public-private partnership, and that limit rests on the conflict of interest inherent to investigations and enforcement. So on the law enforcement side, Britain and Europe have a pretty good system called the 4x4 or the 5x5x5 system to provide information sharing between agencies, and that doesn't really exist outside Europe in the same way, and to be honest isn't really understood that well in Europe in some areas. So there should be more emphasis, more training, more resources going into law enforcement intelligence sharing, so that we can safely share intelligence which is graded by an intelligence unit, by professionals, so it can be shared and risk assessed, and we don't do enough of that. And we need more money and more technical skills in law enforcement to do that better.
On that point, of sharing and reporting back, so if we jump back to your earlier point about the chain, private sector, FIU, law enforcement, and you were saying about feeding information back to the private sector. I spoke to estate agents, particularly in the London region, and that was one of the issues that came up for discussion. Some of them wanted to hear more information. They wanted feedback on what they submitted, was it useful, and so forth. Others had no interest. They said, I've done my job, I filed a SAR, I'm safe, I've protected myself, now it's over to you. You're a fan of sharing, giving feedback back to the reporter?
I am, and I do think that we need to change the narrative, and I think this is a role for government and law enforcement agencies to change the narrative away from it being a financial, economic, fiscal thing to being real harm, real crime, real damage to communities, because that's what money laundering is about. This is about poverty being caused, about people dying, and the planet being destroyed by environmental crime. And we need to change the narrative to make this all together much more about harm to the planet, harm to people, poverty and crime, and much less about a bit of a financial regulation thing. So there's much more that should be done to improve that narrative. And the book is trying to make that change as well, by saying this is about all of us.
Well, Tristram, if it all works well, you have the report from the private sector, FIU shares, law enforcement investigates, and it all works out. So let's say they're investigating a PEP, for example, so a politically exposed person, and they freeze and ultimately confiscate the proceeds of corruption from the victim state. And the question that we have here in the chat is, what next, essentially? Because the question is, are there any mechanism or tools that we could use to prevent successfully recovered assets from corrupt proceeds from being stolen again? Because if the NCA, for example, confiscate money here, return it to the host or the victim country, what is to stop it from being stolen again? Because it does happen, and there are many examples of that, as the question says, money going back into the corruption cycle again.
Yeah, I mean, it is a difficult one, and I think the world has come to this quite late. The recycling of confiscated assets is something that is relatively new. But as it happens, I've been working on a project with the European Union to look at how confiscated assets can be shared with communities who are victims of crime, and how it can be returned as compensation to victims when they've been identified. And there is good practice in the world, in Europe, in the Balkans, where I've been working. There's some good examples in Kenya, where the EACC, the Ethics and Anti-Corruption Commission in Kenya, have been successfully convicting corrupt people, confiscating their assets and returning them to communities. So it can be done. One of my criticisms, actually, of the FATF is that it doesn't have a good enough mechanism to spread good practice. And I've found good practice around the world, and I share it within my world, but the FATF is a huge organisation, and it should inbuild the sharing of good practice, and it really doesn't do that. And I've given an example in the book about the European Union, which had a similar evaluation process dealing with financial investigation, and part of that was recommendations from each country to say, this country's got a good process, and they promulgate it within the union. And at the same time, the union makes recommendations to that country of good practice that is from the rest of the union. So they had this sharing process built into the system, and I think the FATF should have the same thing built in.
Well, Tristram, a counterpoint there, it flows nicely, because if we look in the chat, we have a question You mentioned the EU, but the question here has a much more, seems to be a more critical perspective on this, because it said, could you share your thoughts on the tick list approach followed by domestic legislators, particularly looking at the EU directives? And we're up to number 6 now, and we're seeing more work being done. We're going to see potential for an EU-wide supervisor or regulator. And the question here says, there does not seem to exist much room to escape that tick box approach coming from the EU.
It's a valid criticism, and the fact that we're on our 6th AML directive is not an indicator of success. It's actually an indicator of failure, isn't it, really? Because we keep having directives and we keep having directives. I think the philosophy is wrong, and part of that is that within the directives, it says that financial intelligence units should be properly supported by member states, but there's no mention of more resources for the prosecutors and law enforcement, who are the end users, and that is missing from the directives. And we now have a situation, it's not in the book because the ALMA wasn't yet on the cards at the time, where we're going to have 500 extra posts linking together financial intelligence units. Just imagine if we had 500 extra financial investigators or prosecutors to actually confiscate the assets. That's my point, that we have this imbalance in resourcing, and we're pouring money and resources into financial intelligence units in the European Union and all over the world. They are relatively, in my view, having visited dozens of them, they're relatively well resourced compared to the financial investigators and prosecutors who actually use the information that they have, who are not supported in the same way, and there are just far too few of them.
I think it's a point that has been made quite strongly about the approach here in the UK. If you do look at POCA, for whatever faults it might have, it arguably is one of the strongest pieces of legislation in this area across the world. But no matter how good legislation might be, if it's not enforced, if you don't have the resources to apply it, to enforce it, it's going to struggle. And it's one of the points that does come out in your book as well, that you do need to properly resource this whole area.
Yeah, and there's just one comment I would make, if I was able to wave my magic wand. The POCA introduced the concept of cash forfeiture. And the point is made in the book that we find cash all the time, and we used to not seize it. And then POCA came along, and we had financial investigators to do the litigation. And that did change things really substantially in the UK. And I think that would work around the world if we had a cash seizure power, and we were able to as we can in the UK and Ireland and parts of the United States and the Caribbean, if we can arrest cash, prosecute cash, and confiscate cash as a particular thing, then that would be would raise awareness immediately. It would be a quick win for countries to realise that they can actually get money straight out of the criminal system into the legitimate economy in a way that's very, very immediate. So I think it's something I would say, and I do say this in the book.
If you were to do that though, Tristram, if you were to arrest the cash, seize the property and so on, essentially what I'm building up to here, what next? So what should happen the confiscated property, whether the house, the jewellery, the cash and so forth?
Well, the criminal assets should be recycled, compensation to victims if they can be identified, and compensation to society if specific victims can't be identified. And I think there is room for a virtuous circle, but it does need to be spoken about. And we do have money going back through various schemes in the UK and Europe and around the world, but there's not enough said about the assets going back into communities to prevent crime. So we need to change the narrative. We need to do a lot more of it.
If you were doing that though, if you were recycling the money back, either compensating the victims, or where that's not possible, as you say, recycling it back to society, possibly an example of that is the cashback for communities in Scotland. But there is a more controversial approach that applies in the US. You have policing for profit. In the UK, there's the ARIS scheme, the Asset Recovery Incentivization Scheme. And under ARIS, up to 50% can go back to the law enforcement agency involved in the process. And that has been subject to criticism by some, but welcomed by many. What are your thoughts?
Well, I'm a bit of both. I was actually responsible for implementing the ARIS in the Metropolitan Police. I was very pleased with the results of the incentive scheme, which I think made a huge contribution to raising awareness among middle and senior managers in the Metropolitan Police, and really massively increased the amount of money that was seized and confiscated from criminals. I mean, it really did make a huge difference. The issue for the UK is that we never put a review date into the scheme. So we've lost sight, I think, of the incentivization part, which is in the acronym, and we're not actually focused on whether it's actually still incentivizing, and perhaps it's now been written into budgets and assumed to be there. And I think Britain provides an example of how you can do it. It went really well for the first 10 years, record confiscations, record numbers of people. And I do think this is about people, not about money. Record numbers of people who were affected by the Proceeds of Crime Act. And the incentive scheme worked really well. And then it didn't. So that's why I say I'm answering yes and no to that question.
Tristram, we know the book, as you mentioned, is about solutions. So if I put you on the spot here, because I know confiscation is one of your passionate areas, what would you like to see done to confiscation, whether law or practice, here in the UK or globally?
Yeah, here in the UK. Well, I do think that we have separated economic crime from crime. And this is a generic problem around the world, that we've taken financial crime or white collar crime, we've used those kind of specialist terms to describe something which is just crime and criminals. And the result of that separation is that we've given it to a few specialists. So we've deprived those types of crime from the resources that are available to other crimes. And the result is we have far too few resources going into economic, financial, white-collar crime, because it's falsely regarded as a specialist crime. It is just a crime, but financial investigation is a technique which could be applied to all crime, and was applied in the UK. So there are examples of financial investigation being used against financial hooligans, against domestic violence perpetrators, against disorderly public houses. There was no limit to financial intelligence and financial investigation, because financial intelligence is all about people. So my plea is around bringing economic crime back into crime, so it's properly resourced, properly politically looked at. And one of the weaknesses in the UK is we've fraud in a separate category and starved it of resources. And now we find that it's 40% of crime. Well, you know, that was by design, not by accident.
Just on this point though, of bringing white-collar crime, financial crime, economic crime back into crime to ensure that it gets the needed resources. But if you look at the criminal justice system more widely, some would argue that that is actually creaking and it's no longer fit for purpose, partly because of resourcing. We see barristers going on strike in the last couple of months. We hear regularly about conditions in different courts around the country, or the buildings themselves being sold off, different agencies being overloaded, overworked. And if you then bring economic crime, etc., back into this general area, is the system not likely to just collapse? And by keeping it separate, does it keep a political focus on economic crime, even if everything else is falling down the priority list?
Okay, it's a bit difficult to clearly answer that, because Britain's got a particular issue over the last, since 2010, essentially, the criminal justice system, all parts of it, have been starved of resources, and we can see the results across the piece. So Britain's unusual. Most countries are developing their criminal justice systems rather than taking them apart. And the result is, yes, you're right. If you overload it with more systems, then you could argue it's already broken. Clearly, overloading it with more work will not solve the problem. The issue, I think, for the UK is the new economic crime plan puts more resources into that particular area against the background of a system which is otherwise not working at all, or severely debilitated. So you're going to get some very skewed results from that. Yeah, Britain's not in a good place, honestly, in terms of criminal justice. So it's a bit unusual in terms of the world, because the world mostly tends to be improving in that area.
If I just pick up on one point, I am conscious of time, and I know this isn't technically an issue within the book, but I know you have experience across financial crime writ large. But just because you mentioned fraud there are a lot of developments going on almost on a daily basis here. One of which includes, we heard yesterday, proposals for a new offence of failure to prevent fraud. Any thoughts on that, or on other current proposals to tackle economic crime in the new proposals?
Yeah, there have been a slew of ideas over the last 10, 15 years. Unexpected wealth orders, deferred prosecution agreements, now this new offence of failing to prevent. And other countries are doing something similar in terms of the unexplained wealth crime in France, for example, and other mechanisms to get at criminal assets which have been obtained through corruption and fraud. A lot of this seems to be a response to a more basic problem, which is, as Geoffrey Robertson puts it, frauds are all very simple. I tell you a lie, you give me money. All frauds come down to that. And I actually agree with that. And if you go to a corridor outside a fraud trial, someone connected with that will be able to explain the case in 4 or 5 sentences. In just a minute or two, they can explain the case. And yet in the courtroom, it takes 6 months and costs £500,000. We really should be strategically looking at that gap between the fact you can explain a fraud case very, very simply, but in the courtroom, it takes a huge amount of time and money. And the Law Commission could usefully spend their time doing that rather than coming up with peripheral ideas to solve a much more basic problem.
Thanks, Tristram. And before I ask my last question, I'm just putting a message in the chat for everyone, in case anyone is interested in our event next week on corporate crime. It just seems a particularly opportune time to take advantage and promote that based on your answer. Tristram, last question from myself. Let's say you go to bed tonight and something magical happens overnight and you wake up in the morning and money laundering is no more, financial crime is dealt with, So essentially, back to the question that is considered in the book, what happens if you win the war?
Well, we're winning the law. We're winning the war not against money laundering, but against crime. And actually, we live in quite a lawless world. And in particular, I think we should all be concerned about environmental crime and about crimes which condemn people to lives of poverty with insufficient health and education and security. And if we win this war on dirty money, then actually we'll make millions of people live in a better world where the rule of law is exercised and where the proceeds of crime are routinely confiscated in the rare occasions when they happen. That's where we should be.
Thanks, Tristram. And as has already been said, this is a book of solutions. So if people are genuinely interested in finding a way forward in relation to money laundering, confiscation, etc., this book is certainly well worth a read. It is very thought-provoking, and it has inspired many conversations already in the short couple of weeks since it has been published. I don't think it will go out of date. I know that will be your desire because it would show you're winning the war, but I think it will be on bookshelves for many years to come. Tristram, thank you so much. I really enjoyed that discussion and hearing your views.
Thank you very much, Colin. It's been a pleasure. Thanks for the opportunity.